I call Scott Simpson.
155 for 3, Mr Speaker. I understand that members of the public who are listening to this debate on the Statutes Amendment Bill number 4, its third and final reading in the House this afternoon, will probably be only those members of the public who are unable to, for one reason or another, find themselves in front of a television or listening to an alternative radio station. And notice that the House is full and ready ready to go for this concluding debate. So it's somewhat surprising and interesting that I find myself speaking in this debate as one who has not sat on the Government Administration Committee that considered this bill and its various component parts. I listened intently to earlier debate from members across the House, Mr Speaker, and was particularly interested in the commentary of my colleague Brett Hudson in his attempt to understand the term omnibus. And it put me in mind, sir, not wanting to deviate too much from the bill, but it put me in mind, sir, of my long ago legal studies when, of course, those students who study legal system and legal practice and all those important matters will well know that the man on the Clapham omnibus is, of course, the standard reference in legal terms for reasonableness. And it's a term that goes back to a time when horse-drawn and long vehicles for passenger conveyance were regular. Clapham, I'm told, was a sort of a nondescript London suburb that a reasonably well-educated person who might be the hypothetical reasonable man, they were probably more concerned about or less concerned about gender equality in those days, but the reasonable man, the hypothetical reasonable man, would be a traveller on the Clapham omnibus. And so it seems appropriate and somehow relevant that this long vehicle of a bill should in fact reflect the nature of an omnibus being a long vehicle, and the component parts of this bill are indeed long, but they're important nonetheless. And, sir, one of the things that always fascinates me as a chair of a select committee and as a member of this House is that the level of detail that we are required to be conscious of as legislators is at sometimes overwhelming. There can be occasions when the sheer size of the legislation we are confronted with is so daunting and detailed in its manner and style that it is very difficult to get every I dotted and every T crossed. Sir, this bill attempts to resolve some of those issues that occur from time to time when an I is not dotted or a T is not crossed. And I'm particularly mindful, Mr Speaker, of the time when I was chairing the Justice and Electoral Committee in the last Parliament, and we were considering the Judicature Modernisation Bill, a bill of 1,200 pages. And my heart went out to the PCO officers who were responsible for drafting that legislation. I simply don't know how they were able to keep to terms and on the detail of each particular clause and each wording of it. It seems to me to be particularly concerning. The senior whips just handed me a note, sir, 162 for 3 after 33 overs, and it's a drinks break. So Parliament's audience will probably increase while the drinks break is on. Sir, I want to turn to several of the measures in the bill because although they are, as we have already heard from numerous speakers across the House, not controversial, they are nonetheless important, and they raise detailed issues that we as legislators do have to consider and from time to time do need to make amendment to. And this process is a neat and efficient way of doing that in terms of the efficiency of this Parliament and the efficiency of the way that we create law and make provision for sometimes things that some people would occasionally think were quite mundane, quite ordinary and quite unspectacular in their nature. The reality is that, of course, that's not the case. Often these sometimes apparently small matters are, in fact, very significant, albeit to a small or narrow range of people. I was particularly interested, Mr. Speaker, Select Committee's recommendations regarding legal professional privilege, because this is an area that is, I think, sometimes overlooked by members of the public, but it's of course a very important area. So the committee came back and recommended that clauses should be removed that would have amended the Local Government Official Information and Meetings Act of 1987 and the Official Information Act of 1982, as those amendments in those acts would have included a definition of legal privilege from the Evidence Act dating back to 2006. But this definition could then be, or it may have been, able to be interpreted to restrict the legal professional privilege to circumstances where proceedings were in train or contemplated. And that was simply not the intention of the amendments. So the committee, I think, wisely made a decision on that, and that has been included in the amended bill that is before us today. So there are a number of quite fascinating pieces of statute that are being addressed in this piece of legislation. I want to refer with the goodwill of the House to several of them. I particularly want to refer to the Births, Deaths and Marriages and Relationships Registration Act of 1995. Now, Part 4 of this omnibus bill and Clause 15 of the bill will make a change that allows for the Registrar General to require persons lodging a statutory declaration for a change of name to provide evidence of their identity and other information necessary to process the application. Now, why is this important? Well, it's important because it's actually very important for the person who is seeking to change their name that their information is accepted and taken as pivotal to the application for change. And until now, my understanding is that that may not necessarily have been the case, and there may have been a number of unreasonable barriers placed in front of people who wanted to make a change of that nature and who, for one reason or another, were precluded from it. Similarly, sir, in Part 8 of the bill, at Clause 23, there is to be an amendment to the Friendly Societies and Credit Union Act of 1982. And this is a provision that will repeal the requirement for the Registrar of Friendly Societies and Credit Unions to prepare an annual report. Now, on the face of it, you'd say, well, it's perfectly reasonable for the Registrar of Friendly Societies and Credit Unions to prepare an annual report, and that report should appropriately and properly be presented to Parliament. However, what has happened since the original legislation was passed by this House back in 1982 is that the report that is still required, well, until now, required to have been provided annually, is no longer of any value at all, since credit unions and insurers are now prudentially supervised by no less a body than the Reserve Bank themselves. So, sir, it's no longer appropriate, even though it seemed sensible and appropriate and good legislation at the time, way back in 1982, for an annual report to be presented to the House. That's no longer current or relevant. So another area, and just a final one that I'd like to highlight before my time expires, is in Part 12 of the bill, which relates to the Land Transport Act of 1998, in Clause 34 of the bill, where consequential amendments were overlooked when that Act was amended to allow the use of vacutainers in the collection of blood specimens in matters relating to blood alcohol assessments and blood alcohol driving offences. Now, so the use of vacutainers is a relatively new technology, and it's one that was simply by omission and non-conspiratorial error, really, just simply omitted from the original bill. And so this Statutes Amendment Bill is a good example of how a small but important detail such as that can in fact be relatively easy remedied by this Parliament in an efficient and sensible way. So the Other speakers who have been participating in this debate have, I think, neatly and appropriately summed up the whole purpose and common sense of this vehicle for making a wide range of minor but significant and important changes to legislation. I commend it to the House.